Hey everybody, the topic I'd like to speak with you today about is land ownership in Thailand and the use of nominees to own land by foreigners. Some of you have seen the news lately. It's rather big news in Thailand that a very prominent law firm in Thailand had its offices raided last week. Their offices were in Bangkok, Samui, and Phuket, and the basis of the raid by the Thai police was suspected nominee ownership to circumvent Thai land laws. So the purpose of this video is to explain a little bit about land ownership and nominee ownership in Thailand, the problems with it, and also some history and background of the use of nominees in Thailand. What is a nominee? A nominee is an owner in name only. So it would be a situation where a real owner or a beneficial owner could not own the land legally or could not own a company or some other asset legally. So he would find someone else to own it for him. So the reason why this becomes important in Thailand is because there are many laws in Thailand that prohibit foreign ownership. For example, the land law prohibits foreign ownership of land in Thailand. The Foreign Business Act prohibits foreigners from engaging in and owning certain types of businesses. So traditionally, law firms have used nominees in order to circumvent these. In recent years, the law has become more strict, and regulations at various agencies and ministries have become more severe, more strict, and there's been more scrutiny. The way this all started is, in addition to the regular development of the law in Thailand, there was a very big case several years ago due to the political situation. There was a candidate that was ultimately exiled from Thailand who was a very big businessman, and he had a large company that he sold to a foreign company. The foreign company was alleged to have used nominee Thai owners to make the company majority Thai. This led the Thai legislatures to revise the law and make the prohibition against foreign ownership to include prohibiting the use of Thai nominees in order to circumvent the law and to provide various administrative and legal mechanisms in order to root out, to pierce the veil of companies in order to determine whether they were owned by nominees or were genuinely owned by Thai people. Once the law began to change several years ago, the two main laws that were changed were the Foreign Business Act and then regulations at both the Land Department and at the Business Registration Department. The Foreign Business Act was revised so that instead of looking at nominal ownership or surface ownership of shares in a company, they would pierce the veil and look at actual ownership. Now, going back into time, the history of the use of nominees, in the past, what was used to effectively use nominees in order to circumvent the law, and I'm not recommending any of this, by the way, was the use of pledge share agreements, share pledge agreements, and also use of differential voting rights. So a share pledge agreement is where the foreigner would loan money to a Thai person in order to purchase a share, and the Thai person would enter into a pledge back to the foreigner that if he could not pay the money back, the shares would be returned to the foreigner, and the foreigner could transfer the shares again to another Thai nominee shareholder or a genuine Thai nominee shareholder, or maybe the law would have changed by that time and allow for foreign ownership. After the law changed several years ago, the Foreign Business Act prohibited this practice. Some of the other mechanisms that were used were the execution by the Thai shareholder of powers of attorney granting the foreign director the rights to transfer a share, or having the Thai shareholder actually execute share transfer forms in advance. So if there was ever an issue, the foreigner would be able to gain control of those shares and transfer them to a new nominee. In reality, the use of nominees is totally illegal. It's primarily used in law companies and real estate companies in order to allow foreigners to purchase houses and land in Thailand. The problem that's developed is that many of these companies use the same shareholder, the same Thai shareholder in multiple companies. Now, if somebody complains and the Land Department, the police, the Ministry of Commerce investigates, they will question the Thai nominee owner, the shareholder, and determine whether he's a genuine shareholder. It's fairly easy to do because they'll look at his bank records and whether he actually paid for those shares or not. So in reality, the use of nominee ownership to own land or for foreigners to engage in prohibited businesses is prohibited in Thailand. The only time a foreigner can own land in Thailand legally is by inheritance. In other words, if he was married to a Thai person or his parents were Thai and they devised him the land, but there are still even exceptions and qualifications there. The device of the land cannot be according to a will. It has to be pursuant to the law only, and the land or house involved cannot exceed 1 rai, and it must be used as a foreigner's residence. Now, there are ways for foreigners to gain a legal interest in land for residents, even for the term of their life, that does not involve violating the Thai law. You should contact a reputable law firm, lawyer, in order to determine these methods and seek out alternative methods other than nominee ownership in order to accomplish your goals in Thailand.